All right, people. We may hear some noise early on into this stream. We have a cranky kid who doesn't seem to be getting less cranky with nap time. And a mic. Let's see. Is this thing on? Mic check 1, 2. All right, people. Don't put the F's in the comment section because I think you're being serious. Is the audio and is the video good? And let me make sure that we're live on, before I say it, before we are live on, we're not live on Rumble just yet. We'll see what happens. Okay. And let's just make sure that we're good on the YouTubes. Rumble just yet. We're good. Okay. We're live. My goodness, look at that chat going crazy. Okay, people, let's bring these screens down and let us say good evening. How's everybody doing this weekend? So apparently I haven't been watching the CPAC because I've been not home today. But apparently Trump's speech is running late. So maybe that's why there's Fs in the chat already, in that we are going to be competing with the CPAC. And I don't want to say competing. I totally understand that people are going to be watching CPAC. This will be on the internet afterwards. So there's no need to miss the CPAC, which would probably be much less interesting to watch after the fact than this. This is going to be relatively timeless. New t-shirt. This is the first day of the rest of my life. It's a good expression. It's too long for a t-shirt, though. Mike, thank you very much for the super chat. And I missed Harold Pastian says, Viva, well, the Betamax is set to record Gunsmoke, and I'm ready to go with Hope. This is worth missing, Miss Kitty. Okay. We have a good show tonight. Good show. We have a good stream tonight. Lots of topics, lots of amazing things that happened over the last week. But lots of big news on the channel. March is going to be a ridiculous month for live streams on Viva Fry. Robert and I think it was more Robert's idea than mine, but we said, we want to do like another stream every week on Wednesday with a guest. And between Robert and I, we tapped into 5 guests for March, which are going to be amazing. Starting with this Wednesday, Dave Rubin. At some point, we got Mike Cernovich. At another point, we got Jack Posobiec. At another point, we got Nerdrotic and Doomcock or Doomclock. I forget which one it is. So it's going to, and these are every Wednesday. It's going to be amazing, where it's going to be, beyond law to some extent. We're going to talk culture. We're going to talk other issues, and it's going to be an amazing evolution. And it's going to add some depth and some breadth to the channel. It won't be substituting for the daily, the daily vlogs, but the vlogs, which I'm going to continue doing, weekly live streams, but it's going to be beautiful. What was the other big news? Before I get there, let me just go to this super chat, which I missed. It was yellow. I see the yellow. I see 2 of them. Canada confirmed living in the past. The God Emperor has spoken. MAGA. Okay. I haven't been on the internet all day. Trump spoke at CPAC. It was a great speech. Ask Robert what his take on is of this. I will, which brings us to item 2 of the news checklist. I'm going live tomorrow at noon with fellow lawyer YouTuber Nate Brody and Ian Corzine. And if you don't know Ian Corzine, he's also got a great law YouTube channel. Ian Corzine, Heart of the Matter, I think was he's your social media lawyer. And so we're going to talk CPAC. We're going to go over CPAC and we're going to talk Cuomo, among other things. It's going to be a good stream, noon Eastern Standard Time tomorrow, 9 Pacific. Okay, so what else? What do we have on the menu for tonight? I'm not your buddy, guy. At what point do you stand up and say no more? Will fear, greed, and ignorance get us a ticket into fascism? Depends what you mean by no more. Someone had posted a comment on my video from today, but I'm going to talk about that in a second. It's internet. I say internet talk where everyone's like, okay, well, the legal channels don't work. At what point do we go to non-legal channels? And I was going to respond, but I saw the person actually deleted their comment, and I was going to respond. Never, in my humble opinion. People may not like it. You never do things that are illegal or violent for one obvious reason. First of all, it's not in my nature, but I know people are going to say you're a passive Canuck, and that's why you're having the problems you're having. The one obvious reason is that is, to some extent, we've talked about it on this channel, exactly what the powers that be would want, so they can then go pass laws qualifying every group as domestic, T-words. They want people to storm Capitol buildings so they can then have an inauguration that consists entirely of National Guard. And that is the way the push and pull works. There's Sun Tzu, or I don't know who it was, but says when you pick a fight, you better make sure that you can win it. But to some extent and to some degree, I have no doubt that the constant needling and the constant pushing of this envelope is precisely to get a reaction that would then justify nothing less than martial law. So from a moral perspective, I don't support it. And from a practical perspective, if it achieves the exact opposite result of that which you want, you're cutting off your nose to spite your face, giving yourself one moment of some form of satisfaction when it is going to utterly disserve your purpose. McClenko, Mr. Clean, I like. Thank you very much. Which brings us into standard disclaimer for the week. Woo finally set a reminder. Nick Schaeffler, who is also, you can tell by that little icon, a member, a channel member. Nick, thank you very much. We got that. I think I missed a couple of chats. Which brings us into the standard disclaimer. I'm going to miss chats. I thank you for all the support. It is amazing, and it's fantastic, and it's encouraging and humbling. I am going to miss super chats. If it's going to make you upset that I don't get to your super chat, don't give the super chat. And I say that not to be cocky or high and whatever. I'll feel bad if you feel bad. So if you're going to feel bad, that's the disclaimer. It's to support the channel. I appreciate all the support. There are multiple ways to do it, but if you're going to be miffed, if I miss your super chat, please do not give a super chat. Beavis Wallace in the house says, from McAllen, Texas, there's a YouTube channel called Cooking with Dog. You should start a vlogging with Winston. We can do that. I might actually just start a channel for Winston, or I might just do regular updates on my second channel, Viva Family. The cooking channels, I'm not a good cook, but the Viva Family, which is my second channel, is going to have a lot of Winston because I want to follow his progression with his eyes. Thus far, his eyes are darn good. Seem to be getting better. But no, it's not bad. Cooking with Winston, he would probably eat half of whatever it is that we're preparing. Kudos to the kiddos. First big pike. Great vid, Dave. Oh, I also have a lot of fishing videos on this channel. If you go back into the past, lots and lots of fishing videos. So what do we have on the menu tonight? So much stuff. It doesn't stop. It just doesn't stop. We're going to talk about Clarence Thomas's dissenting opinion, which seems to have gotten him in trouble with Amazon. I'm sure it's just a coincidence, the timing of a dissenting opinion, which, as far as I said in my video, he said one time too many, I think, that, the ballots at issue in Pennsylvania would never have been determinative, but it might be determinate in the future. But his blistering dissent, which basically said to the Supreme Court, what are you doing not taking this case? You're losing the support of the people. And rightly so, by not adjudicating on one of these cases and setting the rules clear. We're going to talk about it with Robert. We'll get into the dissent. What happens? Apparently, Amazon stops offering his documentary for streaming. You can still buy it on DVD, however much more it costs and however long it takes to get the DVD. But lo and behold, I don't know what the reasons were. Apparently, his documentary is no longer available for streaming on Amazon. I'm sure it's a coincidence. I'm sure it had nothing to do with anything. It's just funny how these coincidences happen. Tim Stewart, thank you for all the informative flow of intelligence. I do my best, man, but I tell you, Robert sends me homework throughout the week, and then I spend the better part of the weekend stressing out about whether or not I'm going to get through all of the reading material. I got a little irritated at Amazon because it literally is Black History Month. And they literally are, in my humble opinion, what is the word? Like a reprisal, retribution. They are, someone help me with the word that I'm looking for. Sanctioning, punishing, Thomas, ostensibly, economically. Soft censorship. We still have your DVD, Mr. Thomas, Mr. Justice Thomas. But during Black History Month, for whatever the reason, we've decided to take down or not offer your documentary for live streaming. Or for streaming off Amazon. If it's an accident, it's one heck of a, lightning in a bottle accident. David Harrington, when will left and right populists realize they're on the same side? I think we're getting there. I just love seeing people open their eyes to what's going on in the world with these COVID measures. And I've seen the transition. I've seen people who were staunch supporters from the beginning, unquestioning supporters from the beginning. Even they are privately starting to ask questions, starting to not support these measures, which at the very least in Quebec and to a lesser degree Canada, but more so Canada than in the United States, are getting more and more draconian as time goes on and not less and less. We're entering year 2 of the 2-week lockdown to flatten the curve. We are literally in Quebec entering week 7 of François Legault's 4-week curfew. And from all the stats that I've seen, the numbers are all dropping. Must be the curfew working, except the stats have been dropping in in Ontario, which an hour to the west has the same reduction drop in cases and incidents, more so in every other state. So one tunnel vision, I would say the supreme leader Legault is going to say, look, the curfew worked, but it's been working the same wherever else without a curfew. Week seven of the curfew. I see Robert is in the house, so let me just finish with some ranting here. What do we see here? Viva, are you going to put your Viva family channel on Rumble too? I have a Viva random on Rumble. It doesn't have all the family stuff, but you're right. Why the heck wouldn't I be doing that? I'm going to do that tomorrow. Thank you for the tip, Jason. Okay, got Clarence Thomas. We're going to have Biden, not Biden. Don't know who's pulling the strings behind this. The airstrikes, international law. We're going to talk about the Supreme Court decision coming out of California, I believe. We're going to talk the quarantine hotels. And I'm going to have to describe it in words that are not going to get the stream demonetized, because my video detailing what I think is a massively important issue got demonetized. And I don't care about the monetization on one video out of 50. I care about the fact that it destroys the reach of the video because YouTube does not recommend it. You know what? Actually, on that note, hold on. Private chat. Let me just get this here. I'm going to cut this. Go to comments. Here is one of the videos, people. Watch it. Share it. Here's the second one from today. And then, how do I copy this? Copy. And then I'm going to bring in the Barnes because I think people are getting fed up with me. These videos, when they get demonetized, the one from today was not demonetized. It's the one about the quarantine hotels that got demonetized. And that's the one where I post on social media. And I'm flabbergasted to see who defends that. We'll talk about it later. I'll save my rant, but just remind me about the thing that I want to say about crime is probably just as likely, if not less likely, to happen at a quarantine hotel. Remind me about that. Okay. With that said, people, also, share the stream around because YouTube doesn't really send notifications anymore but they do, but sometimes they're 12 hours late for a live stream, which is no good. Do you foresee a state or area trying to leave the union? In the States, we talked about it. Let's bring in Robert and see what he has to say. Robert, how you doing?
Good.
We did talk about this, right? We talked about it 2 weeks ago. The Confederacy, what do they call it?
Secession.
Secession, but it was secession of states, but there was also the Confederacy of the States.
Well, the Convention of States, but that was to change the Constitution itself. Just going through state legislators rather than going through Congress.
Okay, so we won't go over it again, but we've talked about it in previous streams. We'll see. Do you foresee, Robert, before we get started, any secession from the United States, and how would that work?
I thought that was because it was one of our locals' questions, and I was going to reverse it because you probably have more experience with that than anybody in modern history, which is the history of Quebec. So what was your take of how did that work or not work in the case of the attempts to do so in Quebec?
So it's an amazing thing. For those of you who don't know, we had in Quebec 2 referendums for separation. One was in 78. The other one was in 96. The day of the second one in 96, while everyone was out in the streets protesting, I went to see the movie Powder, which, if anybody remembers, is a garbage movie. It's probably the worst movie ever made, if not close. But I was not out in the streets then. I was 16 years old and oblivious. Yeah, so we had 2 attempts to separate the province from Canada because there's a strong nationalist sentiment in Quebec, which I don't condemn. I have no problem with it. They wanted to separate. So they had a referendum which said if we get more than 50% of the population to approve the question, which was oddly enough totally backwards drafted to a point where nobody understood it, then they would make the appropriate constitutional moves to separate from Canada. What ended up happening? They had a Supreme Court decision adjudicate on the process that would be required in order to separate. I have to refresh my memory on it, but the bottom line is there's a process that you'd have to go through that it ultimately would require, basically would require approval of the Crown to separate. But you'd have to have a big enough movement and have a clear enough answer to the question. And the question's coming up again now because Quebec has not had it on the forefront as much, 2 failed referendums. But now the West is saying, God, if Quebec and Toronto and Ontario want to vote for Trudeau, the West wants out of this country. And now they have this movement called Wexit. So I might do a video on it at some point. It's complicated and sort of dry, but it's Canadian. But if there's a guy named JJ McCullough, who, if you don't know, does purely Canadian content, he may have already discussed it, but you may want to check him out. JJ McCullough. But in the States,
that's the only modern example of that. I mean, obviously we had the Civil War that kind of resolved the question of whether or not you could secede on your own in the United States. But the only contemporary example is the attempt of Quebec to create its own province, to sort of carve out this huge part of Canada from Canada. And so I think that people should look at that example historically, how it went through politically and whatnot, because it would give some of the context for the problems of trying to do so here. Now, I think you could have practical secession rather than, sort of de facto secession, where you just where you refuse to enforce certain executive orders. You create not sanctuary cities, but sanctuary states. And I think so you could see something like that occur, and you're seeing some examples of it already. You saw some examples of it during Trump's era. So but I don't think legal, it came up again because there's some Oregon counties that say they don't want to be in Oregon anymore. They don't want to be Greater Portland. They want to be Greater Idaho. And so that's where it came up. And there is a constitutional process for that, but you basically have to usually get the state's permission and Congress's permission in order to do that.
I mean, and that's my recollection of what the Supreme Court clarified in the decision. They said ultimately it's gray zone law, but it seems that it would require the Crown to approve. So you'd have to have a pretty decisive decision to move. When Quebec lost the referendum, when they lost the vote to separate, it was like 51 to 49. It was nail bitingly close, but nobody knew what was going to happen, even if it passed for the second time. But no, it's interesting. Then the issue also became logistics. Like even if Quebec managed to separate, you then have geographically landlocked portions of Canada, the east, which would have Quebec as a separate country, blocking it from the rest of Canada. You'd have border issues, currency issues. What would the currency of Quebec be? So I say we may have dodged a bullet in the sense that it might have created absolute havoc had it passed. I think just showing the desire to have a sovereign state allowed for support for laws that were there to preserve the French culture. That it was probably more helpful for that than for separating, because you see that 49% of the population wants its own country. You're going to have more political support, if not to separate, at the very least to enact laws like our language laws to preserve French language, French culture. But it was an interesting year, 96. Robert, do we start with Clarence Thomas?
Sure, I think that's a good place to start.
Yeah. So for everyone who doesn't know, I mean, we did it. He rendered another. It's called an advisory opinion, or is it as good as a judgment?
It's a dissenting opinion, so it's something that can be cited. It's not obviously binding precedent because it's dissenting, but it is a decision that can be cited. Okay, so Supreme Court 6-3. I think it was Gorsuch, Alito, and Thomas who were dissenting. Said they're not going to hear any of the lawsuits. I think it was unanimous for a bunch of the lawsuits, the election lawsuits, and it was 6-3 for the Pennsylvania lawsuit. Yep. And Justice Thomas wrote what I think in the law is a blistering dissent, basically saying it makes no sense not to hear this. What are we waiting for? It's causing problems, loss of faith in the system, and that was it. So what can happen now? I mean, are there any remaining election lawsuits to be heard, or is it officially 2020 election lawsuits are done and moving on? The 2020 election lawsuits are pretty much done. I mean, there's some other ones that are still up on petition for cert, but if they weren't going to take the Pennsylvania case, they weren't going to take any. And not surprisingly, the decisive vote for denial of cert was Amy Coney Barrett. So the all those folks that were lecturing me back in the fall can send in their apologies on the YouTube commentary. If you want to continue to troll me, of course, remember you have to go to vivabarneslaw.locals.com because that's the only place where I'm guaranteed to read your trolling comment. But I mean, it was unfortunate. It was the president's probably one of his biggest mistakes, given that he could have got a lot of people through, and that he ended up with McConnell's choice. And now people understand why I was being critical of this being McConnell's choice and what that meant for the election disputes in particular, but also potentially the COVID cases, which we'll get into. So she was if she had voted yes, they would have had to take cert and would have had to hear the whole issue. And that would have put Kavanaugh in a difficult bind, because then he would have likely had to have joined the decision to overturn, because he previously made comments to the effect that what Pennsylvania was doing was unconstitutional. For those that don't remember the dispute or the controversy, the big question with the election, in my view, and in many key allies of the president's view, was not about fraud, was not about machines, was not about Dominion, was not about any of those things. It was whether or not the election was conducted in a constitutionally conforming manner. Did only constitutionally qualified voters vote? Did they only vote by a constitutionally qualified method? And was the count and canvass of those votes done in a constitutionally consistent manner? With the big question being, were those rules that were established by the state legislature, or were those rules established by the executive branch or by the judicial branch or by someone else? And in Pennsylvania, the key rules in question were clearly not passed by the legislature. They were imposed by the Pennsylvania Supreme Court against the express and explicit will of the Pennsylvania legislature. And so in the Electors Clause of the U.S. Constitution provides that only the state legislature can set the rules for a presidential election. And so they had previously hinted that this was problematic prior to the election, but Barrett was also the decisive vote to not taking it prior to the election. Then the excuse was, golly gee, it's even though I'm the greatest and smartest justice in history, according to some Federalist Society types, I just can't come up to speed on it. It's so confusing. Now that illusion is gone. That had nothing to do with what she did and why she did it. And so she was the key vote to not granting cert here. You're on mute.
Thank you. Do they have to grant cert if 4 judges vote for it?
Yep, that's it. All you need is 4 for cert. You need 5 for a majority, but 4 for cert. And so she was the decisive vote. But, Kavanaugh was not too much of a surprise, and Kavanaugh was Kennedy's choice. So that wasn't Trump's choice or even McConnell's choice. Kavanaugh was, Kennedy said he would only step down if Trump nominated Kavanaugh as his replacement. And so that was an understandable quid pro quo. So Barrett was always going to be the decisive. Roberts was a Bushite and unreliable. So Barrett was always going to be the decisive vote about whether the Supreme Court heard the issue, because once the issue is heard, it's very hard for Kavanaugh. It's frankly even hard for Roberts to pretend that the Electors Clause doesn't mean what it says it means. That's why they chose the Pontius Pilate pretext of standing. And here they chose mootness, which is really ridiculous. As Thomas notes in his dissent, election cases have always been exempt from mootness. And for those who don't know, mootness is another Pontius Pilate pretext invented by the courts to excuse them having to resolve disputes that they decide they don't want to resolve for political reasons. People who believe in the various sort of nonsense put out by the legal academy is that this is a serious doctrine to avoid hearing controversies that are no longer in question. That's a lot of nonsense in my view. Just look at it historically, its application.
It was the mootness I mentioned in the video had come up in the litigation regarding observations, or the observers who were not allowed to observe. And by the time that question arose, observation had come and gone. And they said, well, this is moot. Now you can pursue the other questions of law in your suit. Thomas, in his dissent, says, first of all, there's an exception to mootness, which is when the issue is likely to arise again in the future, in which case this particular, as a matter of fact, issue might be moot for this particular incident, but it will establish the rule going forward for an event that is likely to recur in the future. He explained perfectly why the argument of mootness was untenable. Yeah. And I think
if you believe in it, and I don't, even if you believe in it, It's always recognized because here's the point. You don't want a government to get away with violating the law because there's no opportunity for the Supreme Court to ever adjudicate it because the violation will have been beyond remedy by the time it reaches the Supreme Court. You incentivized governments breaking the law because, oh, golly gee, you can't get involved in time. Now, the other point I think Thomas was broadly making, and it wouldn't surprise me if there was an implicit quid pro quo back at the time of the Texas decision, that, hey, don't worry, don't take this one, but we'll take one after the election. So to resolve the rules, we just don't want to help Trump. And I think Thomas was sincerely surprised when he keeps coming back to, why are we not taking this case? It's inexplicable to not, because that excuse is now gone. I mean, the election has now been decided. We're not even going to get into an issue of who won or who didn't. We're solely getting into a question of what the rules are. And my guess is that there was an implicit quid pro quo that people like Barrett never planned on honoring. And I think it probably surprised him and disappointed him. And he wrote a blistering but straightforward dissent. I mean, he's not critical of any particular justice. He's not personal in his criticism. He's just pointing out how absurd it is to not take a case of that character, because it's an election case, because it's a Supreme Court case, a kind of case for them to handle. It made no sense not to resolve this issue when it's all it's going to do is beg for that issue to come up in the future. And will they again try to find a way to hide under their desks? So it was an embarrassment. Once again, the Supreme Court was just like the Senate was really on trial in the impeachment. In my view, the Supreme Court was really on trial of whether they took these election cases. And the failure to take any of them just shows how useless the Supreme Court can be. Now, it doesn't mean they're always useless, but it shows how useless they can be in politically controversial cases. And it's a deep disappointment, but it shows what a joke Roberts is. 6 Republican Supreme Court justices, and half of them run and hide. A majority of the Federalist Society justices, because Thomas was not a member, not an active lifelong member. I think he became a member later in life. Were the ones to abandon the core constitutional principles. So people should read its dissent. It's not too long. It's right to the point. It's persuasive to non-lawyers. It was meant to be that way. That made no sense. That whatever pretext they had for not taking the case didn't make sense, and it was just the Supreme Court failing the country in its duties.
It's actually mind-blowing because I didn't fully appreciate. In fact, I didn't know that it only required 4 votes in order to obtain cert. I thought it needed majority, which now makes it all the more, I would say, egregious or relevant that Amy Coney Barrett did not vote in support of it. And for anybody who's been watching this, Robert had been warning about this, among other things, which have all come to fruition in a very meaningful sense. I didn't know that. That really changes the perspective of the decision not to vote for cert. Was there any motivation for the decision not to take it, or they just had mootness and no written decision to not take it?
No written decision. Kagan dissented. Well, no, actually, no, I'm sorry. I'm thinking of the church case. They when you deny cert, you don't have to explain why. So it's Thomas says that the implication is that they're citing mootness, but there's no binding precedent set by the decision, which is also good because otherwise mootness would return in its ugly form, and it used to in the 90s. And that's when the Supreme Court was the court, along with others, to say, no. In an election contest, it's almost never moot because the issue is the kind of issue that is 2 things: capable of repetition and likely to typically evade Supreme Court review. If those 2 things are present, not moot. Under their own doctrine of mootness, and again, I think mootness is a bunch of hogwash, but under that definition of it, and so election contests or election disputes have never been considered moot for the last 20 years or so. So they never should have been. But luckily there was no majority decision that was binding precedent that could be used to reinvigorate mootness. It's my old joke. There's no standing in spring. It's not ripe in spring. It's no standing in summer. It's latches by fall and it's moot by winter. And that's what they actually did. I mean, they're making a mockery of the judiciary. They're making a joke of the judicial system, and they don't understand this. It shows you what tiny little bubbles they live in. And this was one of the big problems with Barrett. She lived in a bubble her whole life, came from old Southern money way back. She had no connection to the real world, no connection to real people. So you can't trust her one iota to do the right thing because she's clueless. She lives in her little legal academy of Federalist Society types that go to the little conferences and drink martinis together and think Ben Shapiro knows something about the world. So these are people who are clueless, and she showed her cluelessness because the biggest damage is to the court itself. They've told all the conservatives, deep institutionalists by nature, by character, by personality, you can't trust us. You can't rely upon us. We're pretty much worth nothing. You can appoint 6 of us, and half of us will run and hide when the time comes and when you really need us. And that's who they did. They condemned the Supreme Court. They judged the justice system itself harshly by their failure to take action.
I mean, and on the issue of mootness, Thomas, he said the issue here was a real one. It was that the state court extended the deadline to receive unmarked, unpost-dated ballots. Basically, we all know it, except, according to Thomas, it affected too few ballots to be determinate, and there was no, there would have been no impact one way or the other. But let's adjudicate on this issue, to get it resolved.
Either the electors clause matters or it doesn't. And right now it doesn't. So hopefully that doesn't mean it won't ever. So the worst scenario was them issuing a decision that totally negated the electors clause. They didn't do that, but their failure to correct now, and frankly, that's a sign that they all know what the right decision would be. The right decision would have been the electors clause made all of these rules invalid, which while it would only apply to the Pennsylvania case in that instance, the principle it would have enunciated would have in fact validated and vindicated the criticism of this election from a constitutional perspective in many other states, because some version of that happened in all of the key swing states, where either the executive branch or the judicial branch changed the rules. And for that, we can cite Time Magazine, who bragged about it.
Well, so this was the discussion I was having with someone privately, where the argument was, look, even Justice Thomas said, even with these specific ballots where they changed the rules in a manner that was not permitted because it was the judicial branch basically changing the legislative elected rules, it was too small to have made a difference. The question I had was, do we know that issue only with the ballots received on election day or afterwards, but on the other issues of rule changes that were made by the courts and not by the legislative, do we know that the number of ballots that could have been affected? I mean, that's.
I mean, there's a strong empirical evidence that if you extended that principle to all the other contexts in which they changed the rules, that there were more than enough ballots to change the outcome. And so and that's probably part of the reason Barrett and others didn't want to take the case, because they weren't out to help Trump. Their loyalty was to McConnell, not to Trump. It is embarrassing that not a single Democratic appointed Supreme Court justice cares enough about the electors clause of the Constitution to step to the plate either. But that's because they understood also the ramifications. Thomas's point was, look, our decision won't make any direct impact whatsoever. And he didn't get into the extended analysis of that, which is the extended application of the doctrine would have been effectively a judicial finding that the election was unconstitutional in many states, and that there was substantial evidence of more votes than the margin of victory in those states that were cast in a manner that was constitutionally questionable. And again, Time Magazine bragged about this. The elites that helped orchestrate this said they deliberately changed the rules mid-election in order to make sure Trump lost. And they believed
in fairness,
that doing so helped them.
They said they did it to fortify, yes.
Not fortify.
They weren't doing it to help Biden or hurt Trump. They were doing it to help the process, make it more democratic.
Yes, exactly.
Now, there was a super chat from who asking about Rumble, Jasper. So I don't think the live stream is working on Rumble yet. There might have been a glitch, but they are live streaming in general. They were live streaming the CPAC. It just didn't work with this particular stream. We were trying to live stream this to Rumble. It will happen. It's not going to happen tonight, not the end of the world, but this stream will be on Rumble anyhow, as of an hour after the stream or tomorrow. Let's see what we got here. Mike Rendon says, Thomas's dissent was in language accessible to the people. It resembles the Constitution itself. Barnes is right. They live in bubbles. think anybody's going to disagree with that. It was the I did not know it needed 4 only of the 9 to accept cert. That really changes things a little bit. I'll never forgive the court for its abdication of duty. I want to put in a meme of duty and have a little Peter Griffin voice going off in my head, but I won't. I just did, though. And we are living in biblical times, corrupt judges. And Durham resigned or was redirected. Please comment. Did I say please? Durham resigned or was redirected. I haven't heard this.
Well, what Biden required, when Trump requested it, it was a huge scandal in the media. Biden, of course, requested that every U.S. attorney who's appointed directly by him resign by the end of February. And so Durham was the U.S. attorney for Connecticut. He's resigned from that position. His special counsel position was appointed directly by the attorney general. So that has to be changed only by the attorney general. So he's still in that position. Anybody expecting anything to come out of that is, I think, smoking something.
Okay, well, that's interesting. I mean, it's great. Well, so nothing is going to come of the election lawsuits this year. Thomas issued his dissent. As far as I'm concerned, it's a logically irrefutable dissent. It's true, even if you accept his proposition that on this particular case it would not have changed the outcome. That would, in theory, be all the more of the reason why the other 6 judges should have all willingly said, let's hear it. And let's decide what rule changes are acceptable, who gets to make these rule changes, and what is the protocol for those rule changes, and how soon before an election they can be implemented to make sure that they are constitutional. It was I say that my only problem is that when you say that people have lost faith in the court system and it only hurts them, I genuinely wonder, do they even appreciate the harm that they've done to the Supreme Court?
I mean, I think Thomas does. And I think to some degree Gorsuch and Alito does, but Thomas, the one who really does. The one who doesn't is Barrett. To some degree, Roberts. But Roberts has been tone deaf for years. Kavanaugh somewhat as well. I'm sure all those people that went to bat for Kavanaugh kind of wondered, why exactly did we go to bat for Kavanaugh? That's the nature of it. That when you appoint, you can't be a change agent and appoint a bunch of insiders. And it was one of the weaknesses of the president all the way through. He kept appointing people that McConnell recommended, and this was the effect of it. I think people underappreciate within the establishment how much they're undermining the credibility and authority of the institutions they represent.
Well, while we're on the subject of the Supreme Court, and I guess it'll touch on a bit of how they discredited themselves with prior decisions, but are reestablishing. First of all, I'm going to just say it out loud. Beavis Wallace, welcome as a member, and thank you very much for all the super chats. Welcome to the club. Sneak peeks for members and locals and Subscribe Star and Patreon supporters of all the vlogs. Let's go to the next Supreme Court decision. I guess it's a good segue. This is coming out of California, 6-3, where they stayed. No, what did they do? They stayed the prohibition of limiting church gatherings that was currently under appeal. So my understanding is that there were limitations on church gatherings that were imposed by the state. They challenged the constitutionality of them. The Court of Appeal said they're going to hear it, but they're not going to suspend application of those limitations pending the appeal. This request, or this case to the Supreme Court, was seeking the overriding of the Court of Appeal's decision not to suspend the limitations. And in a 6-3 decision, all that the Supreme Court said for now is we are suspending application of the restrictions on the basis that they are unconstitutional while the Court of Appeal hears the decision. I didn't miss that much.
Just one component that's different. So the South Bay case decided earlier this month was as to the state of California's restrictions, where they invalidated those restrictions, though they remanded part of it. Barrett said maybe you could ban singing in church if you could prove certain things. And what happened was, but Santa Clara, this was as to Santa Clara County. The county had, despite the Supreme Court ruling, the county decided to try to get around the Supreme Court ruling by just creating different categories of banning. And so they decided that even though you could go to the mall, you couldn't go to church at all. They had a complete ban on the church, any gathering. And their argument was, well, don't worry, this doesn't offend that Supreme Court decision 2 weeks ago, because this is a separate order called gatherings bannings. Our mall order is in a totally different order. And because our gatherings banning doesn't discriminate against churches, don't think of it as discriminatory against churches, even though we place malls in an entirely different order. Because they said people aren't gathering at the mall. They gather at church. They gather for political purposes, and we need to ban all of those. But they don't really gather at the mall. But of course, the medical science basis of this is identical. If being in close social contact with a group of strangers in an indoor environment is such a risk that you can't allow it to occur, how can you say it's okay to go to the mall, but it's not okay to go to church? So it was laughably ludicrous. But the district court bought it. The Ninth Circuit bought it. It shows you how eager they are to come up with excuses. And that's why the Supreme Court summarily reversed. It was like a 1-paragraph order, said, look, this is obvious nonsense. You have to look at all of this in broad context. Our prior order made clear you can't keep doing this. You can't say our rules are about limiting social contact of strangers in indoor settings, and yet apply those rules differently between churches and other places. Now, my own view is that any restriction on the church and on religion and expression should be presumed unconstitutional and meet strict scrutiny. Our Supreme Court has this sort of middle ground that says as long as it's a neutral law that applies to non-churches as much as churches, then they created a loophole that has led to all these legislators and other people trying to figure out ways to drive a Mack truck through them.
Well, and I understand the what is it? Not ideological neutral, but the point of view neutral, I think is what it's called.
Yeah, facially neutral.
So I understand the facially neutral argument that, okay, if we apply it and it applies to everyone equally, the fact that it hits churches will not be unconstitutional, will not be deemed to be unconstitutional. I have trouble reconciling that with the special protection, the constitutional protections that apply to religion in particular. So am I wrong? If you have...
No, you're precisely right. But unfortunately, our Supreme Court came up with this nonsense exception that said you can discriminate against churches as long as you're not trying to discriminate against churches, which has never made any sense to me. The point is everything should be strict scrutiny when it involves political association, press, or religious expression, or petitioning government. If it's any of those four, the fourth one is the one that Barrett couldn't remember at her own Senate hearing. Miss Supreme Court brilliant justice, all my conservative friends said, wonder why she forgot the right to petition. What does that tell you about where she comes from?
We have someone in the locals community. I think he's on. I know if it's the same person, is also a member of the channel Telex, who does the most glorious memes ever. I'm not sure if the meme of Amy Coney Barrett holding up the blank piece of paper that says, "I failed to uphold the Constitution." I'm not sure if that was Talex's, but there was a great meme in the locals board of Amy Coney Barrett holding up that blank piece of paper, which everyone knew was going to be memed into the ground. And it said, "Today I failed to uphold my oath to the Constitution."
Yes.
Yeah. I mean, it's an amazing thing to say, like, you can discriminate against everybody. And the fact that it hits something which is specifically protected in the Constitution, the right to religion, and among other things, freedom of speech, the fact that it hits them incidentally to everything else means it's constitutional, which to me would still mean it's unconstitutional, because America was built on certain principles, one of which was affording specific constitutional protections to certain things. And we're seeing the fact that those get devalued over time. We're seeing the impact, the devastating impact it's having. But
it was still a good ruling. I mean, so despite all of those restrictions, the Supreme Court did see through this, struck down Santa Clara's ruling effectively. They said you can't enforce this, which means it's pretty much over. They're just sort of waiting for the final tea leaves to drop, if you will. But it's sad that the Ninth Circuit and the District Court didn't see it in the first place. I mean, this is like the Old South, which between 1880 and 1960 tried to create a bunch of rules to screw over poor people, particularly African American people, but often applied to poor people generally, while pretending that wasn't what they were doing. So that's where they came up with grandfather clauses. Like, okay, you can vote if your grandfather could vote. Ha ha ha. That isn't racially targeting. No. Mm-hmm. It's the same gamesmanship. And at least the Supreme Court exposed it. Now, the reason why I think the Supreme Court will be better, particularly Kavanaugh and Barrett, on these issues is because the church is involved. And you had the Catholic Church, leading church members. You have a powerful institution of the church pushing back. And it was smart. It's credit to Harmeet Dillon, credit to a whole bunch of lawyers on the civil rights side of religious expression who initiated and instigated these suits, because one of the best places to challenge, I mean, I brought one of the first suits, but they settled it quickly, smartly. But the was to do so on religious expression grounds, because the institution of the church is one. You have the purists like Gorsuch and Thomas, and sometimes Alito. But Alito, Kavanaugh, and Barrett all come from church institutional backgrounds. And consequently, I believe they're all Catholic, if I remember correctly. So I think consequently, they're going to be respectful of the religious institutions when those are the ones being targeted. And so far, in 3 separate cases, the only cases the Supreme Court has limited the lockdown so far is not coincidentally been on behalf of the church, where the Catholic Church has been either a party or an amicus to the brief.
No, and I'm thinking in Canada, we do not have these same fundamental values. And there's been a pastor in Alberta. Oh, I'm going to forget his name now. Let me get it. But who was jailed because he said, I'm not turning away people who are coming to pray. And and apparently
Isn't that insane? We live in a world where you could go to jail for praying. We live in a world where you could go to jail for petitioning your government. We live in a world where they could forcibly isolate your child from his own family for weeks. I mean, this is insanity. And anyone who's I consider this a dividing line issue. It's the reason why I'm critical of certain aspects of, people like the show, the Rising that's on the Hill, and Crystal Ball, and some of those people. If this is a deciding issue, if you couldn't get the lockdown right, if you didn't know to stand up for constitutional liberties now, you can never be trusted to stand up for constitutional liberties. And the saddest thing is that so many people have gone along with this, that not enough people have pushed back, that not enough people have resisted. It shows how much fear can get them to do insane things. But when you have people saying, geez, I don't want to lock my 10-year-old in the room for 2 weeks while they cry and beg for interaction, but the government tells me I have to.
It's his name is Pastor James Coates. Pastor James Coates. Look it up if you haven't heard about it yet. Rebel News did a piece on it. I believe the Justice Center for Constitutional Freedoms, John Carpe, I believe they're representing him. It's mind-boggling. And for all of you now, you know what Robert is talking to about the kids being isolated is coming out of Ontario, the Peel region of Ontario. The Peel Health said that if a kid is sent home because the class is canceled because someone in the class tested positive, those kids must self-isolate for 2 weeks. And it's a freaking PDF that they posted to their Peel Regional Health website that says they must self-isolate. If they have to leave their room, they have to stay 2 meters away from anyone else in the house, wear a face mask. What else was there?
You basically have to imprison your own child.
And they were talking kids. We're talking like high schoolers and younger. And at first I read the article.
10-year-olds.
It's what does anyone think a kid is going to do locked up for 2 weeks? It's torturous and it's malicious as far as I'm concerned. But so I read the article. I was like, this can't be true. It's in the Toronto Sun. So I was like, okay, well, Toronto Sun's legit. Then I see a link. The link is legit. And then I go to Twitter where I initially found this, and people in the comment section are saying parents are tweeting about how difficult it is to do this. I don't want to, and there's actual tweets. Oh, it broke my heart hearing my kids sobbing in the other room when we're just a wall apart. Another one said, and we're talking like 8-year-old kids in one of these tweets. And I don't know if the tweets are real tweets, if they're trolls, making absurd scenarios to let people think it's happening. They seem legit. They had avatars. They had people's faces. I don't want to accuse those parents of abuse.
It's government ordered abuse is what it is. It is abuse. It's just who's ordered it.
No, and I'm sure they're saying, oh, it's so difficult. Like we're martyrs now for suffering, but it's for the greater good. It is mind blowing, and it's mind blowing. On the one hand, people are either doing it thinking that it's virtuous and they're suffering for some greater good, or they're doing it because they're actually genuinely afraid the government might come and whisk some people off to a government designated quarantine hotel and not tell them where they're taking their kids.
Where you might get the privilege of being randomly sexually assaulted.
So we'll do that one, and then we're going to talk about this other one. This came out of Montreal, where a woman was assaulted at a quarantine hotel, taken from the airport, told she cannot say where she's going, not told where she's going, and she's in the hotel. Apparently, the context of the story is that she had asked for a bottle of water, which is why she opened her door in the first place. As if, though, you should not be allowed to open your door while you're at a government quarantine hotel. And I love and hate the euphemism, a quarantine hotel. It's like Hotel California. And she gets assaulted by this guy who gets arrested, and then some people are like, well, what did she open her door for? And it's like, oh my goodness, you went there. And I know that other people are probably saying to themselves, oh, these types of things happen everywhere. You're probably safer at a quarantine hotel. Well, it's preposterous to the point of not being able to respond to, but I can respond to it nonetheless. When you're detained, and you're detained by an officer, your security and your well-being, once you're detained against your will, or once you're detained under official orders, your security is the responsibility of the detaining officer. And if they can't ensure your safety, it's on them, is one thing. The second thing is, even if you are safer there, you might be safer being babysit by somebody, but if something happens to a kid who's being babysat, doesn't matter whether or not you were safer there or not, there's a responsibility to be borne by the person who had the authority, who had the control, and who was directing the conduct. And I'm sure at some point, if this gets to the government, a lawsuit, the government is going to say they weren't detained because, like this other guy showed you, you could refuse to go, and ultimately we won't detain you. So you were there ultimately by your own decision to willingly participate, and it wasn't a formal government detention. I'm waiting for the government to make that argument. It's bizarro universe. It's bizarro universe. I don't want to talk about it all the time, and I don't want to post it on my personal Facebook, but people don't know what's going on because it's a one article in CTV News. I don't know what page of the digital platform it was on. People don't know. And now that they're finally starting to see how atrocious this is, women being hauled off to quarantine facilities without being told where they're going, and the inevitable happens. Kids being told they have to, parents being told they have to lock up their kid. People are getting outraged. And I'm waiting for arguments from some people to say, okay, well, this case, yeah, they went too far. When they have gone too far in one case, it's an indication that even the decision makers are not following the science and are susceptible of abuse. And in which case, it's just a question as to where you draw the line when the abuse occurs. But I mean, Robert, it's the same thing in the States. You're detained, your security is the responsibility of the detaining officer. I mean, this is basic law everywhere.
Well, I mean, yes. I mean, no question. If you're in the care, custody, or control of the state, then the state bears the burden of what happens to you. Now, in the U.S., they've carved out 100 exceptions. So people you can be locked up against your will because you might be a threat to yourself. And if you inflict the very harm that they are supposed to protect you from, the courts come up with excuses to why they're not responsible. So the immunity doctrine has been constantly expanded so broadly. And again, this derives from the idea that the king governs us and that the king was anointed by God. That's where sovereign immunity comes from. It's another nonsense doctrine. It has no justification in our Constitution. It was made up by the courts to help their politician friends evade responsibility when they do bad. That's what it really is. I have no respect for it whatsoever. You had some justices over the past 40 years actually write some noble dissents on this, but unfortunately, it hasn't made enough headway. And groups like the Federalist Society are happy with sovereign immunity. So, I mean, that's one of my reasons for credit. That wing of the conservative legal academy is untrustworthy because they don't really care about the Constitution. They care about their own sort of corporatist authoritarian version of it. And so it should be the case that they're held responsible, but it depends on the circumstances when they actually are.
No, we'll see if there has to be a suit. There has to be, even if it's only to lose and set the precedent that this is what the government can do and never be held accountable. I mean, and we have a constitution. We have save and except the Second Amendment, which we do not have in Canada. We have the right to not be unlawfully detained, the right to not be subject to unlawful searches and seizures, cruel and unusual punishment, peaceable enjoyment of property. We have a federal constitution, the Charter of Rights, and every province has its own Charter of Human Rights. And it's like, not only are the governments not respecting them, people don't seem to mind until it happens to their kid, their spouse, their parent, or until it's too late. It's
except for that guy walking through the airport.
Oh,
so what's that story?
His name is Chris Sky. Is the real Chris Sky on Instagram, and his last name is Sicario, I think. I don't know what right offhand. If someone knows it, put it in there in the comment section. This guy, so he says a lot of things which are inaccurate. He says a lot of statements which are inaccurate in technically they're accurate in the point that he's trying to make. At one point in the video where he walks through the airport and he says, "This is all you have to do: refuse the stupid test." I'm quoting him. They have no right to detain you, and I'm going to tell them I'm going to walk through. In his interview with the Rebel News, he says, year over year deaths, there's no excess mortality this year compared to last, which is technically incorrect because there was, I'm going to mess up the numbers in Canada. There was an increase year over year. The increase was commensurate with previous years where there was a similar increase between 2017 and 2018 versus 2019 to 2020. But there was an increase. His point was that the increase is not dramatic enough to warrant qualification of a certain thing. Agree or disagree with him. He's right in spirit, but wrong on the numbers on certain things. Other things, he's 100% right. Where he says, I'm going through this air checkpoint. Nobody can force me to go through this test, which is the PCR test, which is sticking an instrument in your nose to get the swab in the back part of your brain. He's right. Under our Quarantine Act, you could be subject to orders and inspections from quarantine officers, but nothing that involves an instrument entering the body. And I suspect officers know this. The face mask is a separate issue. He says he has a medical condition, which is why he wasn't wearing it. But he I didn't know what happened. He posted a video on Instagram. It wasn't clear what happened after he said, I'm walking through, and it looked like he walked through. I thought he was going to get arrested and we'd never hear from him again. He got let through, but he got an $880 ticket, which he says he's going to challenge. But he knows certain things. And I think the police appreciate that he knows certain things. And also when they know that when they're under scrutiny, they're going to behave a little differently than, the way they're going to treat an old grandma who's crossing the border and is told she has to go to a quarantine facility. But Chris,
it shows the power of self-education, because he's not a lawyer, he's not a legal professional, not a medical professional. He's just a self-educated individual, so he can make his own determination about what he thinks the risks are, and can make his own determination, and could see that he had rights that most people didn't realize they had, that he chose to enforce, and that ultimately they had to respect at some level. And he can contest the ticket. I mean, his position was that these tickets, if you contest them, you have a decent chance to win. I don't know whether he's right or not.
Well, I haven't heard anybody going to court and getting a decision on them yet. I know people are paying them. The only question is, would they have won if they contested the legality of it?
But fascinating that you couldn't do what they have is a form of medical informed consent. It sounds like in Canadian law that you can't do certain invasive medical procedures against someone's will.
Well, specifically under the Quarantine Act, Section 14.1, which says, I guess a breathalyzer is a non-invasive method of inspection, although that doesn't work for COVID, but thermometer, temperature, if you had to breathe, if there were a way to test by breathing into a rag, maybe there's ways to do it that would be non-invasive. So this is going to be the legal question, though, is the Quarantine Act says that the officer cannot compel entering the body with an instrument for the purposes of any tests that they can be, order. Okay. How is that going to play out on any mandatory vaccine? The question seems about the mandatory vaccine seems less likely to be asked in Canada. It seems that there's not a lot of public support for that. And people are saying, if you make it mandatory, there's going to be more pushback than if you just allow people to do it voluntarily. But it's specifically in there, can't invade the body. So, this guy knew it. I read through the act. I didn't pick up on that particular detailed nuance. And that's what the PCR test is. I mean, it goes in far. And people have had, I won't say severe allergic reactions, but people have had reactions where this guy in particular, I know from a previous video, unless he's not telling the truth, but no reason to doubt him. He got a blister where they rubbed the swab because of whatever chemical they put on the end of the swab. And so it felt like he said he had a blister in his nasal passage where they put it. And so they said it was an allergic reaction. And that's why he said, I'm never doing it again.
It could be diplomats going through China and They did a different form of COVID swab.
They do an anal swab, which I thought was a joke. Things that you hear on the internet that you think are jokes. And so everyone's making jokes now. It's only a matter of time before you come to Canada, anal swab and straight to a government quarantine hotel. It's what a time to be alive.
No doubt.
You know what? Before we go into the next discussion, 1 hour in, 10,000 people. How many thumbs up are we at? Go hit the thumbs up. And then we get that number going, and YouTube just loves it when it sees the engagement. This is great. 10,000 people now know, at least in Canada, they cannot stick something up your nose, even under the guise of an order coming from a quarantine officer. And actually, just to share the anecdote of someone who I won't mention, identity doesn't matter, but it's someone I know, who came into Canada, had taken the negative test, arrived, and was shuffled into a new line the first day Trudeau announced, you're going to have a new protocol. Now you're getting tested when you come down. And this person who was, tested wearing a mask was forced into a line where she said shoulder to shoulder with international flights for 2 to 3 hours. And so it's just, I don't attribute, what's the word? Malicious intent. And there's going to be a but. I don't attribute malicious intent. But when your measures are so radically idiotic that they achieve the exact opposite purpose of the stated desired purpose, you're either grossly incompetent or you're malicious. And so this idea that people get tested as they're required to do, and they're going to go quarantine anyhow. Now they're shoved into a separate line where they're not able to socially distance, but they're wearing masks with international flights for extended period of times. It's counterintuitive to the point of incompetence or malice. All right. Now, speaking of incompetence or malice, what do we want? Do we want to talk about the international rules that could apply to Biden's most recent airstrikes in Syria, or do you have one that's more applicable?
No, I think that's a good topic. So I mean, basically the same principles of self-defense. So for your international law recognizes, sort of extends doctrines of self-defense to sovereignties, and so if you are taking a military strike, they look at it like you would an individual. Were you acting in self-defense with all the rules that apply to self-defense? And the Biden's administration is kind of is the emphasis, because they really didn't put out anything in writing to explain this or justify this. But their media apologists argued that it was a proportionate self-defense. Hard to see how. The idea is that militias aligned with Iran caused problems in Iraq that was meant to hurt U.S. soldiers. And so going after other Iranian militias in a different country was somehow self-defense in Syria. In my view, it does not fit the definition of, if we took this case and we no longer made it countries, we just made it individuals. If somebody said, well, George and that gang over there attacked a friend of mine in my gang, so I went over and shot a different member of his gang as self-defense. Would anybody call that self-defense? So it's the same thing, just on an international scale, and you substitute sovereignties for people. So I don't think it fits the definition of self-defense to run around bombing Syria for some problem that happened in Iraq that you blame on a third country, Iran.
What's amazing is, the euphemisms that government use. I don't know when this practice started. Maybe it's always been the case of just government propaganda, calling something the name when it's actually the exact opposite. They called them, I forget the term they used. They used defensive strikes. And they used defensive attack. They used these euphemisms, which can only make sense when you just want to abuse of the English language to conceal what you're doing, in the same way they refer to them as quarantine hotels and not prison. So, I mean, I heard it was either Psaki or Biden or someone talking about this, referring to them as defensive strikes, when nothing by and large was immediately going on. Whether or not you think it's good that they have taken out 22 bad people is one thing, but they call them these words which really just leads me to believe, it was in The Simpsons where they said, they give the laws these absurd names when they do the exact opposite. It leads me to believe that it's the exact opposite. Mm-hmm. But and a lot of people, incidentally, were saying on Twitter that it's this political blinders, political bias. Nobody complained when Trump did it. Now they're complaining when Biden did it. My recollection and my personal opinion is the exact opposite. When Trump did it, a lot of people were very angry because he seemed to be violating his non-interventionist policy on which he ran. And I remember having the discussion.
I mean, Paul Watson was, getting heat because he condemned it so strongly that he was, in his own words, quote, off the Trump train. Cernovich, I mean, a whole bunch of conservative social media influencers, conservative people in the conservative independent press. I mean, Alex Jones went on like a 24-hour tirade about it. So people on the right, and then, of course, people on the left condemned it all over the place, including the press secretary. The press secretary herself said, this clearly is not legal. Biden's press secretary now. But that's what she said when Trump did it. Lawrence O'Donnell, MSNBC, said it was terrible, and then now he's totally behind it. So it shows the scam nature of a lot of the people in the press that defend people. But a lot of core Trump supporters correctly criticized him when he did it, and because I didn't think it was proportionate then either, or defensive in any meaningful manner. And he bought into a bogus story, in my view. I mean, a lot of that's been proven later. There have been a lot of whistleblowers to come out and say that the factual predicate for going in at that point was not correct, which if you applied common sense, you could have figured out. But, that doesn't require a hush-hush episode to debunk what took place there. But so I think it was illegal. No major consequence, though. I mean, we haven't declared war since 1945, and we've been doing a lot of bombing and a lot of killing and a lot of shooting and a lot of soldiers since then. It's a flaw in our system.
Well, and the legality aside, I mean, it's you bomb and kill people you bomb and kill people, and then you discuss or impose sanctions on Russia. It really is. I doubt my friend is watching, but when I said when I lost a bet and I said here's what's going to come under a Biden presidency: censorship, deplatforming, war, and China's going to gain dominance on the global scale. Although that was sort of the easiest prediction, and we had 2 before Biden took office, and a month into it, bombing to flex muscle to show what a capable president he is. I didn't like it when Trump did it either. By the way, I felt it violated the premise on which he ran, which was non-interventionism, which is what I said he and Bernie Sanders had in common, which is why I supported to some extent Bernie Sanders on a foreign policy basis. Well,
and to Trump's credit, when he bombed Syria, he just bombed an empty airport, called the Russians like 6 hours beforehand to make sure nobody died and no conflict occurred. Biden was willing to risk a conflict with Russia over it because there's Russian troops on the ground there and Russian military present in Syria, and by calling them a few minutes before, and he killed actual people. And we can't trust the government's representations. This goes back to Julian Assange and WikiLeaks. What he disclosed is that the government's representations about what's happening in Iraq and Afghanistan are almost always false. They were bombing innocent people routinely, killing innocent people routinely. And anyone who believes otherwise is living in denial. And so we can't trust that they didn't kill innocent people. Chances are they probably did. It's just the idea that you can these magical bombs that will only kill the bad guy. It rarely works that way in the real world.
And especially knowing historically the way the bad guys deliberately integrate themselves into populated areas with innocent people, so that it makes it a deterrent to strike. It's it's one of the problems that you've always had fighting these militias that are embedded in cities and populated areas. It's done for a reason.
No doubt.
So Antifa calls it preemptive defensive. They say they are defending, but when they attack people without provocation, they feel justified. Is this suspect?
It's the same bad logic. But yes, it's the same. The whole point of Antifa is if you can pretend you're defending somebody and you're including yourself, then you can justify you doing morally horrendous things. But it's not a legal excuse. So it's not the illegally applicable, but it is their moral excuse for their course of conduct.
Well, I'm not going to read the first part, but Trump ramped up drones to super high levels and killed thousands of people.
And that's a fair criticism of it. That Trump continued to use, that Trump did not stop a lot of the drone warfare taking place, didn't stop the arms trades going forward that led to more war in places like Yemen. So there's plenty of fair criticisms of where Trump went, but he was far less interventionist than any president since Jimmy Carter, and arguably the least interventionist president and the least warmongered president in our history. So at least since World War II. In the modern era of the deep state. So but I mean, they lied to him about where troops were. They routinely lied to him about what was taking place. As I discussed in a Hush Hush episode, they lied to him about what took place about CIA involvement or complicity at some level in the death of the North Korean's half brother. So that happened while he was president. He didn't even know about it, and that's clear by his own statements years later. So it's the nature of the reality is the deep state really runs the show. Men in gray suits run the show, and presidents have just marginal influence.
And I was going to say that, like, I have another friend on another social media platform, and I made a jab, like, I'm not even sure Biden, knows what he doesn't know what he's signing sometimes, and I'm not saying that to make fun of him.
He said that himself. He's like, what am I signing?
And now we know that Kamala Harris was apparently miffed because she didn't get enough of a heads up. It's like, I feel bad because it's a script that's been written, and you just have your figureheads to play the roles while everyone pulling the strings behind does what was scripted from the beginning.
Exactly.
And it is depressing, potentially unlawful on an international scale. Who could possibly hold them accountable? Probably nothing will come of it. And as Saborium said,
well, I think we're probably gonna see escalating conflict. So we're already seeing it. Israel's going into Syria, sees a green light to take their actions there. That's going to escalate things. Iran is escalating things. They're escalating things in Yemen. They're escalating things with Saudi Arabia. We seem to have a total chaotic foreign policy. What they kept criticizing Trump of, he had a coherent foreign policy, just limited by the power of the deep state. Biden does see, other than saying, "Look at us, we have power." There appears to be no other objective. People can watch a show I recommend called The Gaggle on YouTube and now on Rumble with Peter Lavelle and George Samueli, and they've been documenting this as in live time, saying there's no coherent foreign policy here other than idolatry of power for its own sake.
Well, I might
pull out of Yemen, but also undermine Iran, but also we're going to help Saudi Arabia, hurt Saudi Arabia and Yemen, and then help them over here, and then hurt them over there. It's like, what the heck? We're creating a chaotic environment that only justifies building more bombs and building more missiles and more war.
That's you beat me to it, but that was going to be my, the underlying logic is that more conflict, more arms to sell, and who's the biggest seller of international arms?
But you don't have to worry about it. Even though our Secretary of Defense came from Raytheon, a major defense contractor, he's African American, and our Vice President is African American. So it's always better if it's okay to drop bombs as long as it's the right color, race, or gender who's doing so.
Okay, Cleopatra's in the house. She says, and I had to have dinner again. Sorry and anxious to know what I missed. It was a good first hour, Cleopatra, and welcome to the show. Better late than never. Okay, what do we move on to now? Let me see if I missed any.
Transition into talking about names that don't match up to what's in there. The ill-named Equality Act.
Okay, I know nothing about it, so you're gonna have to introduce it, and then I'm gonna ask my questions as you explain what I suspect is going to be an interesting act. So
what they want to do is amend the Civil Rights Act and have all the protections that apply under the Civil Rights Act, including removing certain religious exemptions that currently exist, to allow two additional areas of protection. One is sexual preference. That's not the controversial one so much. The controversial one is gender identity. And that has huge problems. It creates all kinds of contradictions within the law. So, there's laws under the Civil Rights Act. And this is what changes is gender identity and sexual preference are already protected under sexual harassment employment discrimination laws based on the Supreme Court decision last year. This is trying to expand that to all public accommodations, and which the Supreme Court went out of their way to say they were not applying this doctrine to religious institutions, to remove the protection for religious institutions so that the religious institutions would be under these same restrictions. So again, basically treating gender identity as an equal legal standing protected class as race is. Now, by the way, that contradicts gender, right? There's an inherent, like gender right now is a protected class. Gender identity and gender may conflict.
Well, so I do know a little bit more about this than I thought I did, but that was one question that I had is that, it was Gad Sad in a video on YouTube that he put up today that said, describing the times in which we live and one of the things he said is if you think that a biological male who identifies as a female should not be allowed to compete in women's sports, then you're a bigot or you're a transphobe. Now, I without putting it in that hyperbolic way, which the world, people like Gad said need to put it that way. The question I have quite literally is, it's nice now that people say, I want to respect trans rights. But now, does that not come at the expense of women's rights? And so now, are you not actually, in the pursuit of purporting to be non-transphobic and support trans rights, are you not now being misogynistic and not supporting women's rights? Because that's the question. So at what point are you going to...
gender is a biological construct in the law. So the reference to gender as a protected class references your biological status. Gender identity is purely subjective and is not biological. And so you have these contradictions. What happens when, in order to recognize the rights and equal protection for women, you are biological women, you end up, quote unquote, harming someone who is a biological man who identifies as a woman. It creates just inherent contradictions that even lawyers that don't have a political bone in the fight are like, this is going to be hard advice to give to people. Like, what do we tell schools? What do we tell churches? What do we tell? Public accommodations is all over the place. I mean, that impacts a massive scale that's far beyond employment. Employment was a very manageable construct. In my view, has always been, we should have 4-cause limitations on employment. So I didn't have a big problem with it, including gender identity as a protected class in the employment context for federal laws. I understand many of my conservative friends disagree with me on that, and for good cause. I just don't believe anyone should be fired except for a cause. But that's my own view. I apply that in my own life, even though I don't legally have to. The same is true, but that's radically different than public accommodations. I mean, how do you handle restrooms? How do you handle locker rooms? If I choose to identify as a woman on a random day, that means I'm entitled to go into the women's locker room. I'm entitled to go into the women's bathroom, as well as participate in women's sports. This does not make sense, in my view. I don't think this is a popular proposal. I think Democrats are naive. They thought, we'll call it Equality Act, and everybody will jump up. Just like Hasbro was like, everybody's going to love the fact that Potato Head now is just generic Potato Head. Potato Head doesn't know what gender Potato Head is, or may change on a given day. It turned out they got huge backlash. They didn't anticipate that. They should have anticipated that. But so this idea that gender is fluid and it's whatever you call yourself on a random day is not a popular concept within the country. And so they're way ahead of the curve in terms of what's publicly popular. And just lawyers that are trying to advise people that don't care politically one way or the other are like, we don't even know what to advise them because it's inherently contradictory. So I think it's a deeply problematic law that kind of snuck through because the media didn't pay a lot of attention to it. The House has already passed it. And hopefully it will get filibustered and defeated in the Senate because I think it creates massive, massive problems that are unmanageable. And it can have all kinds of ramifications. I mean, for example, does a minor child now have a right against their parents' wishes to change their gender? Even though we have reason to believe in the medical literature by people Dave Rubin and others have interviewed, that many people end up regretting that choice when it's made at a time that they haven't reached the age of majority. So there's all kinds of, somehow you can't vote when you're 12 years old, but you're supposed to be able to change your gender.
Well,
statutorily have a civil right to it.
I know. I said
beyond the curve.
So we had I'm going to bring this super chat up in a second, but we had a decision coming out of British Columbia, which was a 12-year-old kid wanted to go through hormone therapy, and the father said no, and the mother said yes, and then they ended up in court, and the judge basically said the kid can make their own decision because the doctors are supporting the choice for the kid on the basis that kid apparently attempted to take her own life twice, and they said, well, if we don't do it, then the risks outweigh the risk outweighs the cost. You know what I mean? And the judge basically said, the dad can't talk about it publicly because apparently the dad had disclosed the kid's identity publicly, and they said the dad can't talk about it, and basically the kid can go through with it. In reviewing it, all I said is common sense thing. Kids have to wait until they're 18 to get a tattoo, but can now do this to their bodies beforehand. At the very least, that's where some judges and some people seem to be going. And the literature, it's not controversial. The vast majority of these incidents resolve themselves by adulthood, and there's a spokesperson for the cause who says I regret what I did, and nobody should have allowed me to do this. We're developing minds, and it's not what, you should never have been allowed to do it in the first place. But I want to bring this super chat up because it's a good question. So I guess tomorrow I should register my business as a woman-owned and get federal set-aside deals.
Yes, it's one of the many, many problems because they want to. I mean, I understand that they're in their own little woke-topia where this is the norm, and because of the censorship, because of the suppression, they are basically encouraging and incentivizing a mindset where people think certain things are normal that are not. In other words, you have a lot of politicians and others within the Democratic side of the aisle who think that this is popular, not recognizing it's deeply unpopular. Having guys participate in women's sports is just not going to be popular, even if they identify as women and everything else, because the reason for the difference between men and women's sports reflect biological differences. So just because someone self-identifies as something doesn't change the reason for the difference in the sports is biologically rooted. This is Joe Rogan gets a lot of hate for it, but it's one of his key points where he's right, where he's like, look, our sports are defined biologically. They're not defined by gender identity, and the rules of the game are structured that way. And if we change that, we're changing the very rules of the game. And so this is deeply politically problematic, I think. It's deeply problematic from a legal perspective, just because it's hard to the ramifications can go in every crazy direction unimaginable. And so I hope the legislation doesn't get through, but it's going to come down to the Senate. And then it's going to be lawsuits all over the place once this takes place, because Lord knows how to implement it and apply it.
Well, lawsuits on the one hand, but there's going to be Twitter cancellations left, right, and center, because there have been already. Forget who the tennis player was, who basically came out and said the same thing. There's no reason, there's no way a biological male, regardless of gender identity issues, should be allowed to compete in female sports. It's going to destroy women's sports, and yes. It's fundamentally, I won't say misogynistic, but it's fundamentally anti-woman. And so
that's why many leading feminists have problems with it. It undermines a lot of feminism across the board. That's why, and again, this is in the law itself. You're supposed to protect gender and protect gender identity. These things, and gender is biologically defined for legal purposes.
Well, let's take it one step further. What was her name? Oladal, racial identity. I mean, is the next step add racial identity, and someone who identifies as a minority can then apply for minority grants, even though we've seen others already have done it in real time, just on a different basis. And I want to bring this one up, STFUFFS. For anybody who doesn't know what that acronym is, Google it in the Urban Dictionary. You'll know what it means. Let me get this straight. A minor cannot consent to intercourse, but can consent to chemically induced permanent changing of the body.
We had the high-ranking official who helped kill a bunch of old people in Pennsylvania. Apparently that gets you rewarded in the Biden administration, up for a major health department position, who refused to answer questions from the Senator Paul in particular during the confirmation hearings about, hey, maybe we shouldn't force sex changes on 3-year-olds, and refused to answer the question. So that gives you an idea of the mindset that this war on biological science that they're wanting to engage in. And they have their own political justifications for it, are not popular positions when they're put to the public test, when they're publicly debated and discussed and put to a popular vote. And they create legal problems that are severe just because they, again, contradict with the existing laws. You can't protect for gender and gender identity equally. It's just not possible. Anyone that's, I represent a range of clients that are in the as general counsel, outside general counsel. And so part of what I do is look at legislative impacts on how they have to restructure their internal policies and procedures, employment, other things like this. But because this is a public accommodations bill, this has massive application. And then the other big controversy is there's a lot of religions that have certain strong religious beliefs about certain forms of behavior and issues of gender identity and issues of sexual preference where they don't agree with those. Are they going to be forced to hire people that go directly against their core religious tenets, say to teach people in their religious parochial schools? It appears that's the case by the existing legislation. So it's a deeply, deeply problematic bill that has broad-ranging impacts that is only going through because Woketopia is totally out of touch with the real world. And they're trying to legislate something that really just can't be legislated in the first place.
And Aurora Diaz says, if kids can choose their own medical treatment, then I guess Jehovah's Witnesses kids can refuse blood transfusions, or it would be discrimination of a persecuted religious minority.
Right. Well, the irony is, so you could give a civil right to have a gender transformation as a 5-year-old, but you wouldn't have a right against forced vaccinations. I mean, there's all kinds of contradictions here that they have not thought through. Either there's informed consent required or not. Either the age of majority matters or doesn't. And there's just contradictions throughout. So we'll see what it and how it applies under the 14th Amendment is another question, because, gender identity is not a constitutionally protected class. And so what happens when that part of the law contradicts or conflicts with gender protection, which is a constitutionally protected class. So it looks like a debacle, and it's interesting that this is their first big bill out of the gate. For all the things they could be focused on, this is number one priority. Really quite striking, but it would mean the end of women's sports in a meaningful way. But
now, would the bill would apply not just to government entities, but to private entities?
Yes, anybody that has public accommodations. I think civil rights. This is effectively an amendment of the Civil Rights Act. So everything that was meant to prohibit segregation, everything that was meant to prohibit any form of racial discrimination in education and any kind of public accommodation. So the scale of application is massive.
Okay, that's very interesting. Now, what is the next step, and when does it go before the Senate for a vote?
It's already up to the Senate. So I don't know when they're going to schedule it for a vote, but it's already to the Senate. It's already passed the House.
And so when you say that they're going to filibuster it, I've understood the concept, but never actually how it comes into practice. They schedule it for a vote. How long do they have to vote on any bill? I presume
that all depends on their own internal rules. They could never take it up for a vote if they wanted to. They effectively table it. They could sink it into committee for forever. They could bring it up for a vote, but schedule limited debate. They could have open debate. But the way a filibuster effectively works is it mostly kills a bill just because a number of people keep speaking until they basically give up on trying to pass the bill. Right now, the filibuster is still alive as to everything except budget matters or certain budget matters. And they can't shove that into this. But Biden has made clear he'll pass it. So he'll sign it. So it's all up to the Senate and whether some people start objecting. And I think once religious organizations will probably take the lead, but there'll be some others too, because this is deeply problematic legislation. This is an attempt to impose a woke idea on the world that the world is not ready for, and there's good cause for the world to be concerned.
And I just now fully appreciated what the filibuster is. No matter how long they set for the vote, the filibuster is the practice by which, if you set up 3 days for the vote or a week for the vote or 1 hour, it's the practice of just talking until the time runs out, regardless of how much time has been set.
Right.
So how long before they try to eliminate the filibuster rule?
2 Democratic senators have said they will not vote to eliminate the filibuster rule. So they've already limited the filibuster for certain judicial appointments and for certain budget legislation. But both the senator from West Virginia and the Democratic senator from Arizona have said they will not support changing the filibuster rule as to anything else. So assuming that was one of actually our locals' questions was on that precise issue. My view is that both of them will ultimately, at least one of them, will stand by the filibuster in such a way the filibuster will remain a useful tool for the next 2 years.
What would it take in terms of a vote and by whom in order to annul the filibuster?
Oh, you could do so by majority vote.
Majority vote in the House, then the Senate, or strictly in the Senate?
No, just the Senate. Yeah, the filibuster only exists in the Senate now.
Yeah. Back
in the day, it existed in the House. Indeed, the Democratic House used the filibuster to postpone the certification of the 1876 presidential election.
It's first of all, just the fact that you know these things is amazing, and that you can get that information when it's totally relevant. People don't know these things, and now you're learning. When you know history, the current day hypocrisy becomes even more egregious. And when you know history, I guess it gives you sort of like a longer vision of time. Like you can see where things are going based on the way they've been. And most people probably never knew that. And now you know it. And when Twitter comes out and says, you can't talk about this now, it was done in the past.
Yeah, 1876. Just talking about 1876. Not talking about 2020 or anyone that might be named his fraudulency or anything like that.
Learn the filibuster by watching Mr. Smith Goes to Washington. And the only thing I know about Mr. Smith Goes to Washington is the joke they made about it on The Simpsons. That's I learned
Great
a lot.
film, great film. Frank Capra film. Jimmy Stewart. Our first cinematic reference.
Yeah. Oh no, the first one was Powder, but I don't think that counts.
Oh yeah, you're right. But we'll ignore that. We'll pretend that wasn't mentioned.
All right, what do we move on to now? We're at an hour and a half. We got some subjects left here. Hold on.
Yeah, up before the U.S. Supreme Court, and it looks like they're pretty skeptical of the underlying decision. In the latest attempt by the state to carve out an exception to the Fourth Amendment, is they want cops to be able to raid your home in the name of, quote, hot pursuit, which is very vague, very elastic, and very subjective. And of course, if it's hot pursuit, don't need a warrant, don't have time for a warrant. I just got to bust down that door and see what's in your house. This is the general search warrants the British colonial army used that so enraged the populace that led to the Fourth Amendment in the first place, that said you cannot do any search or any seizure without probable cause of a crime or a warrant, or having a warrant in the case of a home. And so they were trying, they're always trying to come up with loopholes and exceptions and variations. That's what the state's always up to. And they have something that sounds good on paper. What happens if the criminal that we're following runs into their house? Do we have to stop and then call to get a warrant? There are certain exigent circumstances that are already exempt from the Fourth Amendment. I mean, and cops use this all the time. They're like, oh, I was scared that someone was hurt inside the house. I knocked it, and that's why I raided the house. And look at this evidence I found and arrested someone. They come up with every bogus, nonsensical story that exists. But they wanted to expand this to, if you're sitting on your front porch, see the police walking up and walk inside, they're in hot pursuit and can now break down the door. So so hopefully the Supreme Court will clarify that hot pursuit is not an exception to the Fourth Amendment. You still got to get a warrant, and it has to meet exigent emergency circumstances that are rare and that are already abused and misused by state officers all across the nation already, that it stays limited to that problematic loophole, and that loophole doesn't dramatically expand in the future. And some of the questions the Supreme Court justices asked in oral argument this week are promising that they will not allow such a broad expansion of this loophole of the Fourth Amendment.
I mean, when you can obtain a warrant as easily as we've seen recently in any event, I mean, I guess by the time you get the warrant, the hot pursuit
takes 2 minutes. You get on the phone and say, hey, Judge, I need some. Okay, you got it.
No, it's amazing. And we've seen the exceptions now in Canada where under the Quarantine Act, anybody can do anything. If they think that if there's an unlawful gathering in a private house, they can come in without a warrant.
Exactly. We don't, and that would be part of hot pursuit. Their hot pursuit was any suspicion of a crime, they can go in and raid your house, as long as you were physically outside of it at some point prior to it within certain temporal context. That's a deeply problem. It's very rare you're in hot pursuit of somebody running down the street who manages to go into their own house. And even in those limited circumstances, you can just wait them out and get a warrant in 2 minutes. And, so the idea this is a serious problem that requires another exception to the Fourth Amendment is a lot of gibberish.
And it's actually very interesting because it's the exact exception that they used in Canada to implement the new alcohol laws, which are that if anyone suspects that you've been drinking within, I think it's 2 hours of having arrived home, they can force a breathalyzer on you in your own home, even if they didn't stop you en route. And I forget what the name of the technique was, but the exception that they said was, well, when we pull people over for DUI or when we pull people over for suspected drunk driving, and what they would do is they would down a Mickey or they would take a swig and drink it and say, look, I wasn't drunk then, but now a breathalyzer is going to be totally tainted. If anybody knows, I think it's called the Bolius defense. If anyone knows it in the chat, let me know. But they said, look, this is the reason why, we can't rely on a standard breathalyzer because they could just take a chug when we stop them and then it'll all be undone and we won't be able to get an accurate test. So if they test positive within an hour or two of having operated the vehicle, we can make presumptions in law. And that involves being able to go to someone's house and say, look, we think you came home drunk, even if you're drunk now because you got home and you're having a martini. They make these overreaching laws based on these exceptions that occur so minimally. It can only lead one to think they're doing it to expand police powers and not for any legitimate pressing concern. Speaking of Miller versus Becerra, is headed en banc in the 9th. Will it eventually be heard by SCOTUS? How will they likely rule? Will the ARs be protected because they are in common use? Heller.
We'll save that for a future case. That's that magazine case we talked about a few months back, where a panel of the Ninth Circuit 2-1 said that the ban on magazines, because it was real simple. You can't get around the Second Amendment by saying, well, you can have a gun, you just can't have any bullets. Right. So they're trying to limit the number of bullets, and they were going to keep going with that. And the 2-1 decision said otherwise. The Ninth Circuit now en banc has taken up the case, which means that the probably the pro-gun control justices want to reverse that decision. And it may get up to the Supreme Court. We will see. The Supreme Court's been dodging Second Amendment cases now for quite some time. So they've had some good ones to take, and they've eluded taking them. But we'll see. So once there's a decision on Bonk, then we'll discuss that again.
Okay, awesome. And James Scott says, Barnes is wrong. Hot pursuit has been an exception for at least 40 years. When pursuing someone, it's not the cop's fault. The pursuit is immediate and the suspect within sight.
Hot pursuit has not been an exception. Certain emergency exemptions exist. So in certain contexts, a hot pursuit can fit the definition of those emergency exceptions. What they've tried to do is take that emergency exception, which means there's some exigent circumstance that if I, as a police officer, take 10 seconds to make a phone call, won't be able to protect someone's life or be able to do my duties. It's that time sensitive, right? But it's not meant to be hot pursuit as its own exemption or exception. That such a degree that whatever we call hot pursuit is, and ask yourself, do you think there's a whole bunch of cases of cops chasing people down the street and then diving into the home and then not being able to get a warrant and the guy somehow escaping through what was that great Mexican drug leader's name? Through some secret tunnel in the bottom. I mean, come on. This is a ludicrous problem. Not a real problem. It's a fake problem. It's a fake problem meant so they can have more excuses to raid your home without a warrant. And and that's all it's about, pure and simple. So any complaining otherwise, I get cops have 100 excuses for this stuff. It's still excuses. The only oath a police officer takes is to the Constitution, and more than a few of them find it inconvenient in they're performing their duties. But it's the only oath they took, and it's what they need to uphold first and foremost.
All right, excellent. Barnes is correct. Dan Flores. No one ever gets tired of hearing that.
Maybe on civil law.
Oh, and apparently I was supposed to shout out on civil law because he did a good reading on the. It was a hearing. It's either SCOTUS or the CPAC. I forget which. Can we do the Twitter case that came out this week? The motion to it wasn't a motion to dismiss. It was the sua sponte order to show cause as to why the lawsuit should not be dismissed. So, okay, we'll start from the beginning on this one. The Hunter Biden computer guy who turned over the computer to the FBI, turned it over to Giuliani, and the New York Post ended up running an article on it, on the findings on that computer of emails, etc., that were highly compromising. Everybody knows the story, but actually not everybody knows the story, because a lot of people didn't ever hear about it until after the election as a result of what happened. But New York Post ran a story with the bombshell revelations of the emails and the connections it showed to certain people in Eastern Europe, etc. That's not the important part. Twitter and Facebook ban the article. They ban the link to the New York Post article, and Twitter in particular. I don't exactly know how they say it, but they justified the banning on the basis that it was hacked materials and therefore violated their terms of use for publishing hacked materials. I think they had more overt statements on the fact that this article was the product of a hackery. So the article was initially banned from Twitter and Facebook. With enough pressure, they actually suspended or put on pause the journalist's Twitter account, so they couldn't tweet. Well,
including the New York Post. New York Post couldn't tweet, I think, for like a week.
So yeah, there was a standoff. I thought it was only with the journalists, but with the New York Post itself, their Twitter feed was suspended for having violated the terms of use, et cetera, et cetera. Ultimately, the story was vindicated in a big way, but by that time, I'd say like I said, the damage had been done. In that the damage had not been done. That the damage of people learning about this, whatever. The computer guy sued Twitter for defamation on the basis that their statements as relates to this incident were defamatory, labeled him a hacker. He started getting death threats, business negative reviews on Yelp, life upended, and he sued for defamation. The judge in the case, Ursula Urugano, I think I forgot the last name, but Ursula, sua sponte, of her own volition, before the defendant, Twitter, had even appeared in the case, says, plaintiff, show me why this case is not barred under Section 230 immunity of the Communications Decency Act. Now, I had a discussion with Nate Brody, who raised some interesting points and made me a little bit more, not concerned, but made me think that this might actually get dismissed more likely. So she says, explain to me why this is not barred under Section 230 Communications Decency Act immunity for moderating content. The plaintiff's argument is that I'm not suing them for moderating content. I'm suing them for defamation because of things they've said that are not under the, that are not precluded under Section 230 or not included under Section 230. That's the argument. Now, the one thing that I had a discussion with Nate, and he made a decent point, is that Twitter's argument is going to be the statements we made about policy, etc., were only made in the sense that we were implementing a policy that was a written policy that we have created in order to moderate content as we are allowed to do under Section 230, and therefore we do have immunity. For whatever the reason is for which we moderate, it's under our terms of use, it's under our policy, and therefore we are, in fact, covered by the immunity under Section 230. In that we're not making specific statements about this guy by name. We're just suggesting that the reason why it was blocked was because of our policies, which we're allowed to moderate, and we have immunity if we do so moderate. So, did they make statements that were specific enough that they would deviate from just implementing a policy that they're allowed to implement under Section 230?
It was two different things. One, that would be an argument on the defamation claim. It would not be a Section 230 argument. Section 230 only covers the acts of moderation. It does not cover any speech made by the platform, period. So it doesn't matter that you say, well, the reason why I lied about somebody was because I'm implementing a policy. Doesn't matter. Read Section 230. It doesn't say that any statement made by a platform is now also immune because of the purpose for which they issued the statement. So the Section 230 has no application to this context whatsoever. And the Section 230 is not a defamation immunity for when the statement is made by Twitter itself. What it is you cannot attribute to Twitter a state or social media platforms a statement made by somebody else. So that's and that's where the confusion can occasionally arise. But Twitter didn't get defamation immunity as part of Section 230. They got defamation immunity for something they only published because somebody else said it. Because you used to have like three kind of levels of defamation liability. The person who said it themselves, the person who distributed the statement, and the person who published the statement. So the concern was so traditionally, like bookstores could be sued back in the day for defamation. Newspaper stands could be sued for defamation. Right now, cable TV people are being sued for defamation based on what somebody else said on their show. So in a lot of the Dominion cases, as an example. So what the goal was to remove two of those three, to say just because you're a distributor of information as a social media platform, or interactive service provider, internet service provider, ISP. Just because you're a distributor or a publisher doesn't make you the person who said it for liability purposes. So in the tech space, you won't be liable the way a newspaper, TV station, bookstore, or newsstand could be. But it never applied to Category 1 when they themselves are the ones making the statement. It doesn't matter what their purpose is from a Section 230 perspective. They're absolutely liable, period. Section 230 is not an immunity. The only question is, did they make a statement about a person? And that's just a defamation defense. So their defense can be and may be that, yes, we refer to these materials as hacked materials, but we didn't say who it was that had hacked them. The problem with that is under defamation law, all that really matters is would people reading the statement think it's about that person? And quite clearly, that's actually what happened. So the same defense was raised in the Covington kids cases that I'm representing the Covington kids on. Was, oh well, we only referenced a photo, we only referenced a group, we didn't give the person's name, we didn't even know the person's name. That's not the standard for colloquium. The standard for colloquium is, would people know it was about that person, not whether you referenced him or not. And here his evidence is just being named as being the source in the New York Post article didn't trigger any problems for him. It was when Twitter said it was a hacked materials that people started defaming him, destroying him, wrecking his business, make him go underground, etc.
You want to talk about, if one wants to talk about dog whistles, I have no doubt they knew darn well what kind of dog whistle that was. Call it a hack and unleash the fury.
And I think it's going to have to be a trial defense. They've made enough allegation that people knew that statement was about him, that Twitter can just argue that they weren't. But can they really? Who else was it? Who else were they referring to when they called it hacked materials?
So, and I'm not to play devil's advocate. Let's just test my reasoning here. Section 230, I appreciate it. It gives you immunity. It gives the platform immunity for things that other content creators might say on their platform, despite their attempts to moderate. Here would be the question. Let's just say they remove something. They don't give a reason why, they just remove it. It's in their terms of service. We can remove whatever.
And they're okay. Then mostly you can't sue them for defamation. So that's what I've been telling people. In fact, we discussed it in the Robert Kennedy case, that what's new now is they're expanding. Like in the past, the way social media platforms protected themselves was they would not give an explanation. They would make no public statement themselves. And people had sued on the grounds that there was a sort of inferential defamation simply by the act of removal. But as long as what the court said, now I think the court's overextended Section 230, but what they said is, as long as the only thing that happened was they chose not to publish it, they chose not to be the distributor of it, then that is protected by Section 230, because even if that act has an implicit statement with it, it's not an explicit statement sufficient to remove it from Section 230 responsibility or the loophole. And I disagree with that scope, but that's where the court's gone. Totally different. They've decided, and everybody's doing this. YouTube's now doing this. Facebook's doing this. They've decided to take it another level and decide to start making statements, which they hadn't done before. This is why Paul Watson is suing Facebook in England. If they had just said, hey, we removed Paul Watson from Facebook, we're not letting him do certain things, that's it, Watson likely doesn't have a claim. Now, Section 230 doesn't apply in England, so it's a different analysis, but similar analysis under defamation law. When does an action constitute defamation with no statement being made? It's only under when you actually make a statement, generally speaking. And they've started making statements, and they've got more and more factually specific. It's because they want to justify what they're doing to the world. They've decided to become a speaker, not just a printer, not just a publisher, not just a platform, not just a distributor, but a speaker. And when you choose to get up on that square and start saying stuff, you're as liable as everybody else. Section 230 doesn't apply to you. And there's, to my knowledge, no court that said otherwise.
And it's the amazing thing. It's when they took down my video, the analysis of AJ's deposition, okay. But when it went to that screen and the video's down so nobody can see what the video said anymore, and they said it violated the terms of service as relates to hate speech, that says something to anybody who reads that but actually can't see the video. And I was like, I said at the time, that I find that defamatory. That is to suggest that I said something hateful.
Yep. And the other problem for them is they're defining these terms. So when I litigated whether or not someone saying the OK sign could be a white power sign, which is absurd on its face, but there's a lot of law out there that says if it's vague, then it's really an opinion. It's not a factual claim. But what they're doing, like take Facebook and Robert Kennedy's case, they defined why they would, if they applied a certain term, they said, we're removing this account for this reason. Because that was the difference. If Instagram had just taken down his account and said nothing, he doesn't really have a suit. But they decided to issue a press release, and they issued a press release referencing another press release where they defined these terms. So, for example, calling someone alt-right, probably you're immune from, unless you're like, say, the New York Times, and you've defined it so that you can go. So if you New York Times call someone alt-right, they can probably be sued. This is one reason why O'Keefe and Project Veritas are suing now in New York Times and other people, but they're realizing that many of these media organizations have made the legal mistake from a defamation perspective of taking what would have been protected opinion and giving it specific factual definitions and saying, if we say this statement or use this adjective about this person, what would go here and look at our little dictionary, and this is what we mean by it. And there it's specific factual statements. And those factual statements you can bring defamation claims on. And that was the mistake Twitter made here, was that they wanted to defend themselves. They didn't have to say anything. And if you look at what all the social media was doing about a year and a half ago and before, they wouldn't say, they would do what they did to Eric Hunley. We've removed your account for violation of community standards. And, Eric's like, which community standard? Well, we removed your account for violation of community standards. Those, you're like, I don't know what that means. But see, there you can't sue them for that. But once they start saying, no, we sued you because that material is hacked, or we said this about you because that material was illicitly, criminally obtained and published, well, then you're on the hook. And Twitter's good. Now, it is disturbing how reflexively biased federal courts are, that their first thing when they see any suit against social media, they think, oh, this has to be barred by Section 230. So it shows you have a problematic judge. And she gave him 5 days to respond, which is ludicrous. What she didn't realize is that she made an embarrassment of herself. Another embarrassing Poppy Bush nominee who went to great lengths to exculpate BuzzFeed from its defamation and issuing the Steele dossier, coming up with every imaginable excuse why that was immune from liability, to where she thought, oh, I'll prove how nonsense this suit is right away. And then that's why the lawyer's response was, it's very simple. We're not suing Twitter for publishing someone else. We're suing Twitter for what they said. And it's Section 230. There's no court in the country, to my knowledge, that has found that Twitter is immune from its own statements. You're on mute.
I was on mute. I was looking for something. The first thing, everybody knows who Awakened with JP is. If you don't, it's some funny stuff. You may not agree with everything he says. I don't, but some of the stuff he does is hilarious. His video about what it's like getting removed from YouTube. I mean, it's too real to be funny, which is the funny thing. I just put the link, so go check that out. But yeah, the judge gave him 5 days, 5 pages to draft a response. And I think they nailed it. I think it didn't need much more than 1 page. But and then she gave a defendant who had not yet appeared a delay to respond. A delay to respond, which is only, am I wrong now? Even if she says, oh, okay, you can proceed, she not just green lighted and effectively templated a motion to dismiss from Twitter now? It's like inviting.
I think she thought she had, but now I think once she realized the response, I think realizes that whatever clerk was that told her that was a good idea probably shouldn't still be a clerk, because I would be embarrassed, humiliated to make such an obvious error like she did. So we'll see.
No, because the only time I got a little discouraged in the sense that she was actually good, she'll grant it, is that she'll say, yeah, they were only saying that they're enforcing their terms of service, which is what Section 230 was intended to, provide immunity from. And to the extent that they're moderating to remove illegal and lascivious content, they're immune, therefore dismissed before Twitter even appears.
Yeah. Their purpose in what their speech is irrelevant to whether they're liable for their speech.
All right. We'll see where that goes, because I'm on that like rice on sushi. I don't know. We're going to be following up on that.
Rice.
White on rice. Okay. What do we have a few minutes left? What do we want to talk about? Did we get everything?
So yeah, there's a couple other components as to the legality of vaccine passports. That goes to the Canadian issue, other issues, conditioning your right to travel on it. We have an interstate right to travel in the United States that's constitutionally protected. That's why states can't even require you to register to vote more than 30 days prior to a presidential election, because of that right to travel. That was the constitutional predicate for it. So the main issue with a vaccine passport requiring you to take certain medications or other things as a condition of having the right to travel would be very problematic between states because of your constitutional right to travel. They have a little bit more authority when they're monitoring borders, your ability to leave and come back. That's why they suspend passports for things like tax deficiencies. But once you have a passport, there's a due process right in its keeping it. And so there'd be constitutional questions about the scope of it. But so the UK is talking about doing it. The US has not yet. But I think there are constitutional constraints on their ability to condition your access to travel on the basis of certain public health components without meeting certain evidentiary predicates. And people can refer back to our debate with
Dershowitz.
Dershowitz on what the constitutional rules governing any kind of compelled vaccine for or conditional contingent access to services or government or your basic rights would be based on a vaccine, and that will give the best overview of the debate.
And they're bringing it up in Quebec. François Legault is talking about a vaccine passport. And this is the amazing thing, and it's one of the most frustrating exchanges I had with someone. I'm not anti-vaxxer, period. The discussion then went to, I'm not anti-vaxxer, but when my kids got the chickenpox vaccine, I did ask questions. Why do they need it? Like, what's the purpose and what's it preventing, et cetera? And what are the risks of getting it and avoiding getting chickenpox as a kid and potentially getting it as an adult? And it devolved into, I don't think everybody should be compelled to take every vaccine, and informed consent is my underlying principle. And then the person effectively said, well, then aren't you, if you're saying you don't think people should take certain vaccines, you're an anti-vaxxer. And I was like, if that's what it has come down to, it's a disingenuous discussion where I don't think you should be compelled to take every vaccine. Some of the ones that, meet, going back to the Dershowitz discussion, that meet certain criteria, safety primarily and efficiency. And we're talking about, like measles and smallpox and things like that. But we are venturing into the realm now where if you don't want to take any vaccine for wholly legitimate reasons, safety, efficacy, how long it's been around for, whatever, now you're going to be labeled and blacklisted. We're entering that territory. So we have our premiers talking about a Quebec passport, a vaccine passport. There's a lot of pushback, but it's almost as though the media and social media and the politicians have framed it that if you push back, you're one of them, and nobody should take you seriously. You should be blacklisted and ostracized. But we have the same constitutional protections. It's just people seem to think that the Constitution was a privilege that can be removed at a whim and not the governing principle through which governments have to operate. But
yeah, I mean, the two major legal phenomenons that created the legal opportunity for the Nazi regime to exist was was an emergency exception written into the Weimar Constitution, and was the lack of respect for informed consent in all forms of public health. That's what allowed all the experimentation to take place from a legal perspective. We said afterward the Nuremberg Code, we would never do it again, and now we're seeing people who want to do it again. And in my view, all these things, if a vaccine is safe and effective, persuade people of its use and allow informed consent to be the guiding light. If we were facing an zombie apocalypse, okay, then we could debate what you could condition someone's access to certain rights are as part of taking public health. But we're not there. But at a minimum, it's always a question of who decides, who has the power. And my view is it always should be for the individual more often than in the concentrated hands of the state. You don't have to be Michael Malice to recognize that fundamental human truth.
And I take it a different step and maybe one step further, but just a different angle. Prove how safe it is and do not give immunity to the vaccine manufacturers, period.
Yeah, exactly. I mean, let juries it's all about who has the power. Let juries let ordinary individuals make the decisions individually. Let juries make the decision collectively if something went wrong. We don't let the white lab coats tell us what to do, and the folks in black robes are no better at letting that be the case.
So we'll see. So there's no determinate answer on that in any jurisdiction yet. The funny thing is, at the beginning when people were objecting to the masks and mandatory masks, I remember Cernovich, who people think I'm kissing his butt, but the dude finds the damning tweets from people who tweet things now compared to what they tweeted way back. But he said at the beginning, he said basically, it's just wear the mask. Okay, just make the law. Okay, now take the vaccine. And now it's going to be law. And it's like, it's a slippery slope that people were complaining about a year ago. And we've gotten there faster, and we're heading further faster at exponential rates. And it is, I've had the discussion privately with people. My issue with the mask was not to object to wearing the mask. I think you'd get meaningful cooperation in the absence of a law. But once you make it legally compelled to wear a mask, that's the new threshold. And then it's just a question of what's the next thing that's going to be legally compelled. And so they'll never do it with vaccines, and they're not doing it by law, but they're doing it by practical reality, conditions of employment, conditions of travel, which is, getting someone else to do what the law can't. It's just as bad, if not worse.
No doubt. But speaking of unconstitutional actions, the CDC's moratorium on evictions was always, it was like, how exactly does the CDC have authority over every landlord-tenant relationship in the country under the guise of public health? And so the court recognized that it was clearly unconstitutional. It was funny reading some lefties criticize it. They're like, what's this Commerce Clause about? And it's like, wow, it shows how far afield some of our constitutional jurisprudence has got, and our constitutional literacy has developed in the country, that people don't even know that the main restraint on the federal government regulating individual behavior within the states is that the Interstate Commerce Clause is the only predicate for them to often exercise such power. So, I mean, the 14th Amendment is what allows civil rights bills to get passed. That's why the Equality Act raises questions, because it wasn't within the intended scope of the 14th Amendment, the idea of gender identity. But the nor was really sexual preference, quite frankly. But you could believe in protecting it, but it isn't a 14th Amendment rooted doctrine, and that raises questions as to whether it's a federal prerogative in the first instance rather than a local state government prerogative. But the court decision was clearly correct. The CDC has no authority to issue a moratorium on evictions on the grounds of public health. They have it's much like their mask mandate on in traveling in a car, in a Uber inside a city. And in fact, that decision may have consequences for forthcoming challenges to the mask mandate of the CDC, because under the same logic, they should have been limited in where federal parks, federal property, fine, so be it. But that's not the same as the subway, the bus, someplace that gets federal funding indirectly. That's never been the means by which they could properly constitutionally enforce it. So it was the correct decision, and hopefully it's a sign of other future pushback to come.
Well, I mean, it seemed like the obvious decision, but I have thought other decisions were obvious as well, and they didn't quite get there.
No doubt. Other good development is critical race theory went on trial in part in Las Vegas this week, and the federal court gave its inclination to grant for the case to go forward on the grounds that it was a coercion and discriminatory, the nature of forcing critical race theory on various public institutions. So it's a good sign of good things to come. It looks like they will have a full trial as early as April. And if they win that, they may set a precedent that will help invalidate critical race theory, which is, in my view, discriminatory in its ideological orientation. It should be voluntary, not compelled or coerced anywhere, and often encourages and incentivizes discrimination. Might start seeing not only political blowback. LinkedIn had to remove its critical race theory lesson. I think Coke is regretting its, be less white mantra that has polar bears disowned from Coca-Cola, representatives in the future. Sort of was a funny meme that was on our locals board. Viva barneslaw.locals.com for those who remember. It's just a lot of fun curated content that comes from people other than either one of us. Just members of the board that come up with fun stuff.
The memes are awesome. The discussion is awesome. There's too much to read in a day, but it makes for good selective reading when you have time. It's amazing.
There's plenty of content. You can digest it as you wish. But that too was a really good decision. I think that covers all the topics we had, other than a few questions. There was a question from Stephen on Locals about the Arizona lawsuits. Very promising. So one election cases that are ongoing is the Arizona Senate is just trying to do a full audit of what happened in Maricopa County. So Maricopa County issued its results of their machines. They cleared the machines. My view is that's actually there's people that have good cause to be skeptical of. I always say, you can't trust Madoff to audit his books. You probably can't trust election officials to audit their own election. So there should be some independent confirmation of party observers and others with a motivation to really double check and cross check everything. But I think that's ultimately, I don't think the machines were the source of any constitutional issues, at least. That's my own opinion. People can think what they want about it. But I do think there's questions about the ballots, signatures and whatnot, including from the state court decision that happened earlier, where a Democratic expert found there were signature match problems. All the Arizona legislature wanted was they just wanted the ballots. These ballots are digitized. What was supposed to be one of the benefits of computer machines involved with ballots one of the only benefits in my view, because I'm not a fan of machines and ballots. But I think people will always be skeptical of whatever outcome. I mean, it's been on both sides by both parties over time. Just look at what Elizabeth Warren and Bernie Sanders said in 2020, by the way, or look at an HBO documentary about this that came out after the election. It just was no longer popular.
No, it is it's atrocious, and at the very least, yes, we need answers, and there needs to be some verification. The most concrete evidence, which I thought was a joke at the time, is Gavin Newsom now wanting signature verification on his recall, and it's. Yeah. I mean, that action alone should preclude Twitter or any other platform from forbidding or restricting or censoring any discussion on the issue. That one gesture or one act alone. But
no doubt. But good news is the court ordered the Maricopa County was refusing to disclose the paper ballots, even though, again, they're all digitized. It's not like some huge administrative project. It's, a little USB stick. But the court ordered them to produce it. So Arizona, the Senate will get a chance to really review and see if there's anything odd with the ballots. And if there is anything wrong with the election that needs to be fixed for future elections, this will help produce the evidence of it. So good work by the Arizona State Legislature. Good work by the court. This should have been public record from the get-go, in my view. But it will be promising to see what's there. Let's have a real audit to make sure people can have confidence in our election procedures moving forward.
And just to answer Cleopatra's question in a manner that we're allowed to answer it, given the constraints of YouTube, these are the next 4 years. This is all going to be a question of how everything plays out leading up to the next election. Everyone wants you to comment on CPAC. Are you going on? Going on with Richard Barris tomorrow?
Yes. So tomorrow I will be on with Richard Barris at 2 p.m. Eastern Time. The People's Pundit. You can find him on YouTube, peoplespunditdaily.com. Also, we'll end up putting up a live stream, I think, at some point. And we'll be discussing everything that, I am wearing the tie in honor of the speech made today. And we'll discuss the speech, CPAC, a whole bunch of things related to that, and all the political news. And may take a few more pot shots at Barrett just for fun, but but all that will be discussed tomorrow.
Okay, excellent. Go for it.
We have Mute Van Mist, which is a very interesting name, Mute Van Mist, or maybe Mute Von Mist. I'm not sure, but asked about militarized DC and why we have the Baghdad-style green zone in Washington DC now, long after the inauguration. It's a sign of, there's two interpretations. Some people, like Tim Pool, believe that the Democratic political establishment and the media establishment and the DC establishment writ large is truly paranoid. They think the masses are coming for them at any given moment. I don't think that's the most credible construction of things. There was a good breakdown on Eric Hunley's unstructured.locals.com channel that's only available on that channel, where a behavior language person did an analysis of AOC, and you can see whether how truthful she might have been, or in her body language analysis as to whether or not. My own view is I don't think they really think that. I think it's a show of power, and it's a sign of a declining empire. This is where Michael Malice, brilliant mind, I think is very apt. He's writing a book called White Pill, and his whole point is, and he's somebody who's an anarchist philosophically, and people are like, "Why are you optimistic about the world?" And he's like, the sign of a rising empire doesn't have a guy like Biden as its president or have a militarized capital. That's the sign of a declining empire that kind of knows that it is. And so that's my loose interpretation of that. And then the last question was about a book on Joe McCarthy called Blacklisted by History. There is an alternative interpretation of Joe McCarthy. My own view is McCarthy still made major mistakes, but much of what's attributed to McCarthyism wasn't by McCarthy. It was the House Un-American Activities Committee that was actually orchestrated by Democrats. And they were the ones who did most of the really pernicious, problematic work. They attributed it to McCarthy, the press did, because they wanted the label to be attached to a Republican from Wisconsin, not some Democrats maybe from Massachusetts, for example.
Okay, excellent. Now I see we're over the 2-hour limit, but we're going to wind it up here. So, I mean, it's an interesting thing. We've seen some good decisions coming out of SCOTUS, some bad decisions coming out of SCOTUS, some good progress on meaningful issues. Incidentally, someone said we should have Michael Malice on at one.
Yes. You may have told him at the beginning, but for everybody, Cassandra and others, everybody who came in a little bit later, the We are going to be doing a Wednesday weekly guest series show, a 1 hour live stream with various guests, usually at 7 p.m. This week may actually be at 6:30. We're figuring out the time. Dave Rubin will be the first guest, and we'll be not interrogating him because that sounds scary from lawyers. We'll just be a friendly chat with interesting intellectuals from across the cultural and political space, including Nerdrotic, Doomcock, Dave Rubin. Hopefully, there's an invite out to Michael Malice, Cassandra Fairbanks, Jack Posobiec, Mike Cernovich. Posobiec's already confirmed. Cernovich is already confirmed. Dave Rubin's already confirmed. Nerdrock and Doomcock have already confirmed. Down the road, probably also with Dershowitz, Bobby Kennedy, some other people. So just fun, engaging, interesting midweek conversations where we mostly ask questions more than discuss things ourselves.
Robert and I are trying to come up with a creative name that captures the essence of what we're going to do, but it is going to be amazing, and we're going to get people from all political spectrums and from all ideological spectrums, and have
just culture, where law intersects with society, politics, culture, art, history, you name it. Just get a wide range of people and ask the kind of questions that I've always wanted to ask. And also we'll crowdsource questions. Not only we have live chats and super chats on either YouTube or Rumble or both, but also we'll have questions on the locals board. And after the show is over, within about 5 or 10 minutes, we'll have an I will be on to do an after party live chat on the locals board, the Viva BarnesLaw.locals.com board. And just for chat for about a half an hour about what we discussed today. And maybe we'll crowdsource ideas for a title for the Wednesday show.
I saw one that said "Lawsome," which is an amazing suggestion already. And someone else asked on what platform. It's going to be on YouTube and it's going to be on Rumble. We were supposed to be live on Rumble tonight, but I think I did something screwy because I don't know anything about tech. Rumble has live streaming now. I don't think it has live commenting yet, but it's in beta. It's going to happen, and so we'll be able to simultaneously stream Rumble, YouTube, and then take the after party to Locals, which is aptly named, I guess, because it sounds like a bar. Robert, and okay, you know what? Everybody needs one dose of optimism, some encouragement for the week to come. Give it, and then we end it.
Well, there's always like the two books behind me. One is a guy who was great at describing the reality of the political world when it started to turn to a certain degree in America, which was always a mixture of sort of some harsh realism, but romantic idealism. And that would be Hunter Thompson. But the other book is a book about fixing the system by Adrian Kuzminski, about how populism has been used historically over civilizations, over time, over countries, over nations, to make positive, real reforms that improve everybody's lives on an everyday basis. And as Trump himself said today, that now is not the time for pessimism or despair. Now is the time for optimism and repair. And that can happen, that will happen, and there's all signs of it. So for every bad case and bad problem, that just provides an opportunity for a good case and a good solution. And I think we've seen as many examples of the latter as we have the former, and hopefully that's the path that continues to happen in moving forward.
All right, amazing. Actually, before we go, what cigar are you smoking this week, or do you have in your mouth this week?
So this one is a Ramona Jonas Exclusivo. It's supposed to be from the Aramis exclusive. So it got rerouted on the chip. So.
All right, now you know, everybody. Thank you very much for tuning in. Stay tuned for the big stuff tomorrow. I'm gonna have Nate Brody, Ian Corzine for a noon. Stay tuned. Big stuff and awesome stuff is coming. Thank you for the support and thank you for the comments and the activity. Robert, thank you as always. Stick around. We'll say our proper goodbyes. Oh yes, everybody. It's on podcast. It's on Rumble, and highlights will come out tomorrow if there are some good distinct highlights. Enjoy the rest of the weekend, and I'll see